Yes, hi everyone. Today I'm going to talk about the counterclaim. Now, what is really a counterclaim? Suppose that somebody sues you through an action, and in his particulars of claim, that he mentions that he claims damages because of the fact that you breached a contract, or because of the fact that you assaulted him, because of the fact you battered him, and etc. 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 And let's say that you filed defense to that. You filed defense to the battery by claiming defamation. You filing defense to the breach of contract by basically claiming misrepresentation and fraud, that you were induced to the contract through fraud and misrepresentation or deceit. You filed defense to the battery by saying that you were defamed under those circumstances. You filed defense under the breach of contract by stating that there is the tort of conversion of property while that contract was operating. Now, let's say that out of this defense, damages have risen. You want to claim damages for the conduct of the plaintiff in your own right. This is going to be done through the counterclaim. Is the counterclaim going to be part of the same pleading? Yes, it's going to be part of the same pleading, although it's a separate claim. However, the counterclaim might as well arise out of your defense, such as in the case of misrepresentation. The defense and counterclaim are virtually the same thing. You claiming misrepresentation, and if as a result of that misrepresentation you have suffered any damages, you can claim them. Is that to say that the defense and the counterclaim are the same thing? No, but they can overlap. Now, when you're done with your defense, it's the time for your counterclaim to begin. So you're going to entitle your defense and counterclaim. This is going to be segmented in two parts. The first is going to be your defense, and the second part is going to be entitled counterclaim, and it's going to follow once you have finished drafting your defense. Now, in the case that your counterclaim arises out of your defense, you will just proceed as normal with your defense. You're going to deny or you're going to admit the allegations stated in the statement of claim, and you are going to mention your version of facts. You can do that either in the same paragraph or in separate paragraphs in your defense. While you're doing that, and there's an overlap between your statement of claim and your defense because they arise out of the same contract, let's say, then you can also state the particulars of the damage that you have suffered. You can also state the particulars of the details of the cause of action that you rely on. If it's misrepresentation, you're going to mention the details, the particulars. If it's negligence, you're going to mention the particulars. It's very important to state in the defense, in a paragraph, that you are going to counterclaim damages relying on certain actions. If it's misrepresentation, it's very important to state that you're going to counterclaim damages based on misrepresentation. Now, once you're done with your defense, which I, for once more, state that it can be your counterclaim at the same time, it's time for you to draft your counterclaim. It's going to be part of the same pleading. So when you're done with your defense, you're going to write a separate heading entitled counterclaim. And under the counterclaim, you're going to set out your counterclaim. The counterclaim is a separate claim, but it is contained in the same pleading, namely the defense and counterclaim. Once you state your counterclaim, for the sake of simplicity and convenience, and so that the pleading is as clear as possible, you can repeat certain parts of your defense which formulate your counterclaim, especially when your counterclaim arises out of the same facts which give rise to your defense. So if it's misrepresentation that you're claiming damages through a counterclaim, there's no point mentioning the misrepresentation again, but you can simply repeat the paragraphs from your defense instead of reciting the entire extracts of the paragraphs under your counterclaim. However, if it's not convenient, and if the counterclaim does not arise out of your defense, but it's a separate claim, then you might proceed setting out the facts that formulate your counterclaim. It is for your own lawyer to rule whether your counterclaim is going to be included in the same pleading or not. However, not including it presents a high risk of your separate claim in a separate proceeding being rejected as being an abusive process or a res judicata, even though it might be a totally different claim, even though there may not be an issue estoppel, which means that there are issues that have been decided, even if there is no cause of action estoppel. That means that the new claim in separate proceeding is going to be the same claim that you could have raised in the earlier proceeding, masqueraded as a new cause of action. However, it could be an abuse process because the same facts and the same circumstances will be discussed twice, and this could have been easily avoided through case management. When you're done setting your counterclaim out, then you will include your prayer and you will specifically ask for damages. And this is the counterclaim. The information here is simply educational and is not legal advice. Thank you.